As head of state, is President Kenyatta exempt from the prosecution before the ICC?
No. According to Article 27 of the Rome Statute, holding a position or an official capacity such as acting as head of state or head of government does not exempt any person from criminal responsibility. By ratifying the Rome Statute, all states parties have agreed on Article 27, which waives any immunity under national or international law. It's important also to highlight that the ICC is not prosecuting Mr. Kenyatta and Mr. Ruto in their official capacities, but for their alleged individual criminal responsibility. The ICC proceedings started long time before Mr. Kenyatta and Mr. Ruto were elected to their current positions, and summonses to appear and not arrest warrants have been issued for them.
In accordance with the AU decision, Kenya is writing to the UN Security Council to defer the ICC proceedings. Will the court oppose that?
Within the framework of the Rome Statute, the United Nations Security Council can defer the ICC Kenya cases for a period of 12 months maximum, and once made, such deferral could be renewed under the same conditions. Any request for deferral submitted to the Security Council will be discussed in that forum, which is separate from the ICC. The ICC is an independent judicial institution that does not advise the United Nations Security Council on whether to adopt or to reject a resolution to defer a case.
Will the ICC suspend the Kenyatta case proceedings until the UN Security Council decides on the deferral request?
The court is a judicial institution, and any requests to postpone the beginning of the trial of Mr. Kenyatta or suspend ongoing proceedings have to be submitted to the relevant chambers in accordance with the applicable procedural rules. Currently, there are no pending requests for postponements of the proceedings in the Kenyatta case. The African Union decision does not constitute a request submitted to the relevant chamber in accordance with the applicable procedural rules. All requests that are submitted to the competent judges according to the applicable rules have been and will be considered in an impartial way by independent ICC judges.
Will Mr. Kenyatta be present at his trial?
As a rule, Article 63 of the Rome Statute, the court's founding treaty, requires the accused to be present during trial. Any exception to this rule has to be submitted to the judges and decided by the ICC judges. Mr. Kenyatta's defense has submitted a request to be excused from being physically present during the trial, and the ICC judges are considering the request, and their decision will be taken in total impartiality. Mr. Kenyatta has also submitted a motion to stay the proceedings, which the judges are also considering.
Did the ICC open the Kenyan cases in order to intervene in the Kenyan political scene?
No. The ICC is an independent judicial institution. The prosecutor's requests are based on the law and evidence, and such requests are presented to independent, impartial judges for consideration and decision. Let us recall why the ICC opened an investigation in Kenya. Following the post-election violence in 2007 and 2008, and following the Waki report, the Kenyan government was given 1 year, beginning of July 2009, to set up a national tribunal to deal with the issue. And failure to do so would mean that the ICC would pick up the matter. But despite several attempts in 2009, the Kenyan parliament did not manage to pass the legislation required to establish a special tribunal. So, on the 5th of November 2009, the ICC prosecutor met with the President and the Prime Minister of Kenya at the time. He informed them that since all the statutory criteria were fulfilled, he would be seeking authorization from the ICC chamber to proceed with an investigation into the situation in Kenya in relation with the post-election violence of 2007 and 2008. And at the time, the President and Prime Minister of Kenya issued a joint statement where they recall their constructive meeting with the prosecutor, and they stated that Kenya was fully committed to cooperate with the ICC within the framework of the Rome Statute. The ICC investigation in Kenya was thus initiated with a strong Kenyan commitment to it. Subsequently, And throughout the Kenyan process, the ICC has demonstrated its neutrality and impartiality. For example, by issuing summonses to appear and not arrest warrants for Kenyan suspects who cooperated with the ICC, by stating on several occasions during the election period that the ICC has no position on the candidatures for the Kenyan presidency, since this is an internal Kenyan issue. And also, for example, when the judges scheduled the trials to the effect that hearings in the two Kenyan cases will not be held at the same time.
The AU decision mentions several issues, including expanding the jurisdiction of the African Court on Human and People's Rights. What are the ICC's views on this, and on the possibility to discuss other issues at the next session of the Assembly of States Parties in November 2013?
The ICC welcomes all genuine efforts to participate in the global fight against impunity by strengthening judicial capacities to be able to prosecute the perpetrators of mass crimes. It should be noted, however, that the Rome Statute does not foresee a role for regional criminal courts, and in this respect, it is recommendable to discuss this initiative in the context of the Assembly of States Parties. The Assembly of States Parties is the right platform to discuss such issues and any other legislative issues or political concerns of states. The ICC, as a purely judicial institution, cannot engage in a political debate and is only bound by its legal rules as established by the states parties.